This meeting of the Senate Finance Committee for April 16th will come to order. We have two bills on the agenda. We're starting with Senate File 4260, Senator Carlson, the Elections Omnibus Budget Bill. Welcome to the committee.
Thank you, Mr. Chair and members. Mr. Chair, I have Senate File 4260, which is the Elections Finance Omnibus Bill. This proposal is focused on bolstering the resources available to local election officials who are the backbone of Minnesota's election system. Last year, I'm proud that we established the Voter Fund, which distributes funding to local governments to help defray in a small part there. How's that? Okay. Helps defray in a small part the many expenses that locals incur to administer elections. Unlike other election-related grant funds that the legislature has established over the years for local governments, the voter funds are guaranteed to continue and are distributed by a formula so that local governments can rely on them and actually build them into their budgets. We were able to invest $1.25 million annually in the voter account last year. This bill shifts funding from other grants to the voter account at the Secretary of State's and counties' requests and adds most of the committee's general fund to target to the fund. With this investment, we're more than doubling the amount that the state is dedicating to defraying costs incurred by local election officials for administering the state's elections. The only other appropriation included in this bill is for the Campaign Finance and Campaign Disclosure Board to provide additional support to campaign treasurers. That's local campaign treasurers. We need to do all we can to support them, given the critical roles they play in our campaigns. They are the keys to campaign finance, compliance, and transparency. The Campaign Finance Board does not have the expertise in adult education, nor the best tools for training treasurers from across the state. This one-time appropriation will provide the board with the resources to improve their online training and support the people who are the key to our system. That is the bill. It's passed the Elections Committee on a unanimous vote. I ask for your support, and as I need to say that we have fit into our target for the Elections Committee. Thank you very much, Mr. Chair, and I ask for your support and happy to answer any questions.
Thank you, Senator Carlson. We'll have Mr. Erickson walk through the spreadsheet unless anybody has any questions before that. If not, please go ahead.
Thank you, Mr. Chair and members. The spreadsheet that you should have in front of you is the spreadsheet for Senate File 4260, first engrossment. And I'll just note that there's a lot of numbers on this page, but actually relatively little new money. What a lot of the bill is doing here is actually moving two existing grant programs that the Secretary of State is not using and moving that into the new voter account that Senator Carlson described. So most of the spreadsheet is showing that there's net zeros, as you see like in section 1, that the transfer that usually goes or has been going to the voting equipment grant account or for drop boxes is being turned off, and then down in section 2 you can see it's being redirected to the voter account. So the two pieces of new money are actually for the voter account, the fourth line under section 2 there, and also in section 4, the campaign treasurer online training development. The voter account increased new money is $450,000 in the current biennium and $100,000 annually in the tails. The campaign treasurer training is $50,000 one time. I'm happy to walk through the bill language if the committee has an interest in seeing how those cost-neutral provisions work to increase the amount to the voter account, but that may be just too much detail.
Are there questions from members of the committee? Discussion on the bill? If not, Senator Friends moves that Senate File 4260 be recommended to pass. Is there further discussion on that motion? If not, all those in favor say aye. Aye. Opposed? No. Motion prevails. Senator Carlson, you got this through here almost as fast as you got it through your own committee.
Thank you, Mr. Chair. And members.
Thank you both. We are, okay, we are going to recess for a few minutes until we get Senator Oumou Verbeten here. With that, we'll recess to the call of chair. Meeting of the Senate Finance Committee will come back to order. Senator Oumou Verbeten, you've got Senate File 4483 on misclassification of employees, and we'll have you briefly explain the bill and then have an amendment, and we'll discuss the fiscal note and so on. But brief explanation first.
Thank you, Mr. Chair. Happy to give you all just kind of a high-level overview of the bill, starting with what employer misclassification fraud is. It occurs when employers mislabel employees as independent contractors to avoid their responsibility to provide workers with guaranteed protections like overtime pay, minimum wage, unemployment insurance, paid family medical leave, earned sick and safe time, and more. It's a huge issue. It's been growing. The most recent OLA report shows this. And the Attorney General also created a task force to study misclassification that I served on as our Senate appointee. We heard hours of testimony from workers and businesses, policy experts. Our task force itself brought together a lot of key stakeholders and experts across different industries. And ultimately, we did adopt some policy recommendations that are in this bill. That's really the result of that. What we see in the OLA report and what we also learned about in the task force is that our agencies are responsible for different components of enforcement. They all have different enforcement authority over this issue. So the Department of Labor, Economic and Employment and Economic Development, Revenue, Commerce, and the Attorney General's Office. Labor enforces fair labor standards, for example, and workers' compensation. DEED enforces unemployment insurance. Commerce has a Commerce Fraud Bureau. Revenue looks at, tax withholding. So those efforts are very disjointed. And we really need a whole of government approach, and that's what Senate File 4483 does. It establishes an intergovernmental misclassification enforcement and education partnership to increase the coordination and collaboration among those 5 different government entities that are responsible for investigating or having enforcement authority over misclassification fraud. And lastly, just want to say that this is an issue that affects everyone: workers, business owners, our community at large. It's not just, stealing the wages and benefits and dignity from workers. Those law-abiding businesses who are doing the right thing really do struggle to compete with those who break the rules to bring down those costs. It steals the resources from our social safety net, like unemployment insurance and paid family medical leave, and then forces taxpayers to really pick up the tab on bills that should have been covered by employers, as well as the overall payroll tax evasion, just shifting that tax burden onto everyone else. So that's why we need this bill. Happy to answer questions, and I think we're going to go through the fiscal note.
And members, we have the A34 appropriations amendment. It's been distributed and it's online. And you will note in this that on line 112, there's a blank appropriation. And that's because as of last night, we learned that there was an error in the fiscal note, and we were hoping to get the new one by this morning, but it has not come. So the plan would be to put this one on with the blank appropriation for the Attorney General's office, and then discuss the bill and any debate and everything else, and then we would have to lay the bill over until we get the fiscal note that would take care of the Attorney General's language there. And with that, I'll turn it over to Mr. Nauman to explain what happened. And
so, Mr. Chair and members, I'll do my best. I called members' attention to beginning on page 9 of the fiscal note. So if you have that in your packets. And the point of this exercise, at least my discussion here, is to just identify what we figured out as a logical inconsistency in the fiscal note. It's a good object lesson for why we read more than the first page of a fiscal note. So on page 9, under contested hearings, there is language that says, as a result of the Department of Labor and Industries' increased investigative and enforcement authority, DLI assumes 3 additional contested matters will be referred to the Office of Administrative Hearings, and each year starting in fiscal 27, and that DLI would be represented by the Office of the Attorney General throughout the proceeding. The rest of that you can read at your leisure, but I think that's the critical sentence. Then if I can ask you to skip to page 15, which is the Attorney General's response. Under assumptions, the language reads, and I'm getting good at reading, so I'll just proceed to read it. The Attorney General's office does not project any defined expenditures, absorbed cost, or revenues from the bill's amendments to MnSTAT chapters 177, 181. The shorthand version of this is we believe that there is an inconsistency in the logic between what DLI, the lead agency on the fiscal note, assumed and what the Office of the Attorney General's office assumed. So Mr. Olofsson identified this last night. We endeavored to see whether or not we could consummate the question and figure out whether in fact the Office of the Attorney General's office does in fact have a cost or should be scored with a cost, which we think is probably true. So thus the language in the amendment that has a blank. So I think with the chair's recommendation, we have put that amendment in front of you, drafted with the fiscal matters that we know, plus blanks for those items that we think are coming later. I think process-wise, if it were the committee's pleasure to adopt the amendment and you would conclude your business here, and any other amendments that you might consider, then the bill would be laid on the table. And we would bring you an engrossment, a committee engrossment, the next time, so that everything would be engrossed for you to consider. So, Mr. Chair, thank you for this opportunity to walk through.
With that, before Mr. Olofsson goes through the bill, I'd like, Senator Friends moves the A34 amendment. And Senator Draheim, did you have your hand up? Okay, well, okay. The A34 amendment, which you should have in your packets, again, it shows the appropriations for the DLI and Department of Revenue, and then a blank appropriation for the Attorney General. Is there any discussion on the amendment, Senator Verbeten?
Thank you, Mr. Chair. Just that I've been in touch with the Attorney General's office, and they do expect to get it done today. I don't know if that'll be ready before the end of this hearing, but appreciate us, staff walking through that, explaining the issue, having this amendment, and once we get that done, happy to come back to the committee as well.
Okay. Is there any discussion on the Friends motion? If not, all those, Senator Murphy.
Thank you, Mr. Chair, and Senator Oumou Verbeten. I'm glad to see this proposal before the committee. And while this is a pause, it's not a very long one. And I think this is really important work that you and others have done for Minnesotans. And I'm excited to move it out of this committee. So I just wanted to thank you while I have a moment about the work that you've done thus far with others to get this into the shape that's in. Thank you, Mr. Chair.
Thank you. Further discussion on the Friends motion? If not, all those in favor say aye. Aye. Opposed? Motion prevails. Mr. Olofsson, you want to go through the fiscal note now?
Sure. Mr. Chair, members of the committee, for the record, Eric Olofsson, Senate Fiscal Analyst for the Labor Committee. In your packets, you should have the consolidated fiscal note for Senate File 4483 with the third engrossment. On the front page of the fiscal note, you'll see a net impact to the general fund of $199,000 of additional expenditures in fiscal year 25, and then net savings to the general fund of $642,000 in fiscal year 26, and again, $642,000 in fiscal year 27. So moving on to the DLI's portion of the fiscal note, on page 5 of the note, you'll see that for expenditures, they'll have $56,000 in FY25, and then $70,000 ongoing, beginning in fiscal year 26, and then from penalty revenue, $712,000 beginning in fiscal year 26 ongoing. So to just better explain where those expenditures are coming from, I'll point you to page 9 of the fiscal note. So for the fiscal note assumes that they'll need approximately 915 hours of a senior labor investigator beginning in fiscal year 25 for outreach and investigation. So 840 hours would be for investigation and 75 hours for outreach each fiscal year. So that comes to an approximate cost of $56,000. And then and then approximately $15,000 would be to reimburse the Office of Administrative Hearings for administrative law judge time. This is for approximately 3 cases, 2 which would be settled out of out of court, and then one contested case hearing that would require the full 40 hours. So for a full 60 hours of administrative law judge time. So that gets us to the 56,000 and 70,000 ongoing. And now moving to page 10 of the fiscal note, this is where we see the penalty revenue, anticipated additional revenue from the bill language. So for general misclassification penalty revenue, it's assumed that the new revenue will start in fiscal year 26, because in fiscal year 25, DLI is going to focus on informing and educating employers and employees. So $612,000 for misclassification penalty revenue ongoing beginning fiscal year 26. For registration penalty revenue, this comes from section 25 of the bill. That's $90,000 ongoing beginning in fiscal year 26. And then for the stop work order penalty revenue, this assumes one stop work order per year beginning in fiscal year 26, and with assumption of about 2 days for each of those stop work orders, so $5,000. So for a total of $10,000 per that one stop order per year. So and that gets to for the total penalty revenue of $712,000 to the general fund beginning in fiscal year 26. Moving on to page 12 for the Office of Administrative Hearings. Here's where you see that administrative law judge time for both the expenditures and the revenues coming in of approximately $15,000. That cancels out due to being reimbursed by DLI. Moving on to page 15, this is the Attorney General piece that will be revised. The note currently says the Attorney Generals will expend or save 0 hours of attorney time, but as Mr. Nauman explained, we believe this will be revised in an updated fiscal note due to what was described on page 9 of the bill of how DLI assumes the AGO will represent them in these case hearings. Moving on to page 18, which describes the Commerce Department. The Commerce Department assumes there's no immediate fiscal impact to the bill. Additionally, on page 21 of the fiscal note, Deed says there should be no fiscal impact to this bill, and that any of the work specified for the intergovernmental misclassification enforcement and education partnership can be done with existing staff. And then for the final agency in the fiscal note, we have the Department of Revenue. They're assuming a one-time cost in fiscal year 25 to the general fund of $143,000 in fiscal year 25. This is for the Department of Revenue's disclosure and records management unit to work on 4 direct agency-to-agency data sharing agreements based on the bill. So for attorney, for appeal, legal, and disclosure staff, they would need one-time funding to work on these agreements. And that wraps up my walkthrough of the fiscal note. With that, I'd be happy to answer any questions.
Thank you, Mr. Olofsson, and again, thanks for all the quick work last night when we found out the error in the fiscal note. I appreciate your taking charge of that. Questions from the committee? Senator Pratt.
Thank you. Thank you, Mr. Chair. I'm wondering why this appropriations section wasn't included, why it was able to pass out of the Labor Committee without any sort of appropriation, since that is a Finance Committee.
Mr. Nauman.
Mr. Chair and Senator Pratt, it's a good question. It's not uncommon, and I would have to check the record in this circumstance. This is the appropriations of the jurisdiction of the Finance Committee, so it's not uncommon to work cross the I's and dot the T's, so to speak, and make sure that we're getting all of the finances in order, and then bring an amendment that handles the finance aspects of the bill in the Finance Committee.
Senator Pratt.
Thank you, Mr. Chair. Well, it's not just that we're setting the appropriations here, which, as Mr. Nauman said, isn't uncommon, but to not even have the appropriation section available for the committee to review to find out that, some of it was going to DOI, some of it was going to DOR, and even if it had been blank appropriations, at least that committee, which is technically a finance committee, would have been able to weigh in on it, ask some questions. So that's my concern, Mr. Chair, and I'll just leave that question open again. Why was it allowed to pass without even an acknowledgement of appropriations?
Senator Pratt, the only thing I can tell you is that the budget chairs are responsible for covering the costs of bills they pass out, and this amount is something that they've been calculating. Again, they had the misunderstanding of how much money would be here, but they are responsible for that in their budget division. Whether they discuss the amounts, the specific amounts or whatever, they are tracking with their fiscal analysts how much is going in through their budget. And I think that's been the past practice as well. And again, they could actually, we've also had it where a bill like this could carry it and have the appropriations carried in the other bill, not just tracked in the other bill, but in the omnibus bill. But here, putting it here, I think this has happened a number of times before, and I think it's a reasonable way to do it. They could also track it in there, carry this language in the omnibus bill, but I think it makes more sense to do it here.
Mr. Chair, if we were just talking about the dollar amounts, I might be willing to agree with you, but the fact that we're adding a whole appropriation section that wasn't reviewed by the committee, I'd make a motion that this bill be referred back to labor.
That's a higher motion than other things. Is there any discussion of Senator Pratt's motion?
Mr. Chair, I request a roll call.
Okay, and I will urge members to vote against this. The Labor Committee has addressed the bill, and I think that this is nothing out of the ordinary. This is something that they are tracking the dollar amount. They are responsible for covering the dollar amount out of their budget, and they have chosen to do so and pass this on to us. So I think we have the capability of discussing this here.
Mr. Chair.
Thank you, Mr. Chair. I'd just like to clarify my concern. It's not necessarily the dollar amount specifically. It's the fact that we're adding a whole appropriation section that wasn't in the bill when it left the Labor Finance Committee. So that's my concern, and I just want to make sure that is clear, because I keep talking about the section being added. You keep talking about the dollar amounts and the monies being tracked on the spreadsheet, and that's not the concern. That's not the reason for my motion.
Further discussion, Senator Pappas and Senator Westrom, then Senator Oumou Verbeten.
Thank you, Mr. Chairman, and I serve on the Labor Committee with Senator Oumou Verbeten, and we certainly were aware that there was going to be an appropriation, and I think that Senator Pratt is right. It should have been added to the bill, but it would have been added to the bill with blank appropriations, because at that point, I don't think we had all the fiscal information. And the fact that this is going on its own rather than the omnibus bill, I think does mean that we didn't have all the information exactly in labor. However, as Senator Marty said, the labor chair does have to take this out of her target and has to account for it when she's doing her omnibus finance bill. So I would urge the members to vote no on the amendment.
Senator Westrom.
Mr. Chair, I guess to the motion and why it would be important to support it. Mr. Chair, we've got division committees set up for the very reason of having them be the ones that look these things over before they come to the Finance Committee, and they're the experts as a committee to look through all of these aspects. And so it really feels like we're going to start using the Finance Committee as the committee of accomplishing whatever we need to accomplish, and then give the subcommittees a pass, or basically say that you're sort of irrelevant, we don't need you in the process, and so the Finance Committee will just start taking over by default. And so I just think it's a terrible direction to be going, and ignoring the work of the committee and the chairs. And so I think we should follow the process, even though it seems like it wasn't maybe ready, but there's lots of things that don't get moved as soon because they're not ready. And so I think it's an appropriate motion to support.
Senator Oumou Verbeten.
Thank you, Mr. Chair. Senator Pappas said a lot of what I was planning to say. We're on the Labor Committee together. The only thing I would add is just that we had our walkthrough of our labor omnibus last week as well. Chair McEwen's aware. It's something I'm not only tracking, the chair is tracking on the Labor Committee.
On Senator Pratt, and then Senator Draheim.
Thank you, Mr. Chair. Well, there was plenty of opportunity to have this discussion and to add this section. This bill went through 4 different committees. I don't know that the Labor Committee had a chance to talk about the appropriation. I don't know how this will affect Senator Latz's target. Maybe it won't. But I think it's a conversation that the Judiciary Committee should have. Certainly, it's a discussion that the Labor Finance Committee should have. I just got a quick text from one of our members. They weren't entirely sure that there was going to be an appropriation specifically out of this bill either. So, because there was no fiscal note available to them, as far as I know, when they had a chance to look at this bill. So, I think this needs to go back through the process. As Senator Oumou Verbeten said, this is being carried as well in the Labor Omnibus Bill, and they'll have the opportunity, and all will have the opportunity to see the corrected fiscal note at that time. So I just would like to renew my motion specifically on the inclusion of appropriations section.
Senator Draheim.
Thank you, Chair. And I won't repeat half of what Pratt said, but I agree with him. And I think the majority might have known about this appropriation, but the minority didn't. And, 4 committee stops without all the information. And, it appears when you look at how the makeup of the working group was, it's very one-sided. I don't see any Republicans or the minority in the task force. And, something as important as this that affects so many working Minnesotans, you think we'd want to get it right and include both the majority and the minority. But the minority has been left out of this process from the beginning. So I think this is a reasonable request. It shouldn't stop anything. They can easily bring this up, have the discussion, and send it back. Please support the amendment.
And members, I also serve on the Labor Committee, and we had a very full discussion of it there, and members of the minority and the majority all had chances to comment and did comment on it. And this is largely a bill deciding what we want to do and how we want to treat misclassification of employees. It's not primarily a finance bill. There are costs and revenues related to it. But again, there are many times in the past where when a bill like this could happen, they have the ability to carry the actual appropriation in their bill, and they can carry the appropriation in this bill. And the fact that we didn't discuss many times bills pass out of those committees before there's even a fiscal note there, and they know if they're passing the bill out, they are responsible for it. We've talked with the chair. We're making sure that they're aware of this. We're not taking up the bill, the final vote on the bill today because we do not have the fiscal note ready. And but I urge you to reject the motion. On Senator Pratt's motion to refer the bill back to the Labor Committee, staff will take the roll.
Senator Marty?
No.
Senator Friends?
No.
Senator Pratt?
Yes.
Senator Champion? Senator Dames?
Yes.
Senator Draheim?
Yes.
Senator Eichhorn?
Aye.
Senator Mohammed?
No.
Senator Murphy?
No.
Senator Pappas?
No.
Senator Westrom?
Yes.
Senator Wickland?
No.
Senator Champion?
There being 5 ayes and 6 nays, the motion does not prevail. Further discussion on the bill. Senator Draheim.
Thank you, Chair. I would like to offer the A32.
Senator Draheim moves the A32 amendment. While the bill is being, the amendment is being passed out, Senator Draheim, you want to speak to it, explain it?
Thank you, Chair. It's a short amendment. You know, we talk about the outreach, the education to employers and employees and to independent contractors, and we don't fund it. We have no money to have this outreach. We have 3.1 million Minnesotans working, and we're not going to have any funds set aside to do the outreach the Department of Labor says they're going to do. We're going to increase fines 10 times what they are now. And we're told they're going to do this outreach, but we don't give them any mechanism or any guidance on what to do or how they're going to pay for it. So my amendment adds some money for the agency to do that. That's it. Thank you.
Thank you, Mr. Chair. Thank you, Senator Draheim. I agree that the outreach is really important. I would just point folks to page 7 of the fiscal note where DLI estimates the FTEs and the hours needed each year to, quote, prepare and disseminate outreach and education materials to reflect the requirements of this bill. So I think that's already reflected in the bill and the current appropriation.
Thank you, Mr. Chair. I do find it kind of interesting when we're talking about this bill, we're going to be raising the fines considerably. We're talking about how we're going to pay for taking care of the legal parts of it, charging these people and having these hearings. So I begin to question, is this really about just raising more money, or is this about educating and making sure that if there are some issues with misclassification, that is brought to the public's attention and to the attention of the people that are involved in the industries doing that, so that they know what's expected and stop doing it. It doesn't seem like that's really of interest in this bill. It's more about let's go after them than it is let's educate them to correct the issue. So I'm certainly going to be supporting this amendment.
Further discussion? Not
Yeah, thank you, Mr. Chairman. I think that's the purpose of the $56,000 in the amendment that the Republicans voted against, is for them to be able to do the outreach. And if you look at the plan, which is convening and leading meetings of the Intergovernmental Misclassification Enforcement Education Partnership, at least quarterly, to provide that kind of outreach, I think it is, as Senator Oumou Verbeten clearly outlined in the fiscal note and in the bill, that outreach is going to take place. Plus, DLI is really known for doing that, and they're not known for over-enforcing penalties. They usually do give a lot of leeway to clear up any misunderstandings, to give the business time to correct the situation before they apply any penalties. So I don't think we need this amendment.
Thank you, Mr. Chair. I'd just like to clarify my colleague's comments. I don't believe, I don't recall no votes against on the amendment itself. I recall no votes on the, yes votes and no votes on the motion to refer. So I just want to clarify the record for that.
Is there further discussion? If not, on the A32 amendment, all those in favor say aye. Aye. Opposed? No. Motion does not prevail. Further discussion or amendments?
Thank you, Mr. Chair. I don't think we've had Senator Oumou Verbeten actually walk through the bill. I'd like to have a general walkthrough of it, particularly focusing on the various financial impacts.
Thank you, Mr. Chair. Just before I go into the walkthrough too, I just wanted to note one more thing in the fiscal note where you'll see several times that DLI talks about the inform and educate process, and that's often what their inquiries into misclassification result in. So that is throughout the fiscal note. It's definitely a priority of this commissioner. In terms of the bill, the first 5 sections are really about the powers and duties of the commissioner. It expands the investigative authority of the commissioner. It adds construction misclassification to compliance order authority. It clarifies and enhances penalty authority. It's intended to really enhance the commissioner's investigative and enforcement authority to more effectively discourage and remedy those violations. Section 6 is really the addition of the private right of action for workers. So if they're misclassified, being able to hold those employers accountable for those violations. Section 7 is about misclassification of employees in general. There is an expansion and more thorough details around the prohibited activities and the remedies, adds additional damages and penalty provisions to the existing law. It allows for individual and successor liability. It expands reporting of violation in relevant local agencies. This is really intended to more broadly address misclassification through like clearer and more detailed prohibitions, make unlawful conduct easier to understand for both employees, employers, and to better facilitate enforcement. And then it's intended to establish penalties that provide meaningful consequences for those violations, to provide deterrence and make misclassification of employees just less of an attractive business model. That's something we've definitely seen not only in the OLA report, but in our task force of like this was an intentional business model for some of those bad actors. And then intended to promote further interagency cooperation and partnership. Then we go to section 8, which is the misclassification of construction employees specifically. That clarifies and broadens the application of the independent contractor test to business entities as well as individuals, modifies the existing test for construction to make those factors clearer, easier to understand and apply, retains the presumption that an individual providing or performing construction services is an employee unless they are operating as a business entity and they meet all those factors that are listed in the test. You can see those there. It refines and clarifies the independent contractor test for people providing or performing building, construction, or improvement services, and really focuses on 2 core questions. Is the asserted independent contractor a separate and legitimate business entity, and is the contractual relationship a legitimate business-to-business transaction? It also addresses who the employer, in instances where a misclassified workforce is retained through like multi-tiered and layered chain of independent contractors. This is another thing we see is that there's like multiple levels of misclassification in construction especially. It expands and more thoroughly details the prohibited activities and remedies, penalties again, requires that a person treating an individual as an independent contractor retain the records that determination is based on and provide those records to the department. If requested to, allows for individual and successor liability. And then again, this revised test is really intended to aid enforcement and assist contractors in determining that employment status as well as demonstrating compliance. I'll move. There's a lot I could say in here, but I'll try to keep us moving. Section 9 is the intergovernmental misclassification enforcement and education partnership. So that's the sort of whole government approach I've been talking about. Includes revenue, commerce, Department of Labor and Industry, Economic Development, and then Attorney General's office. They are the agencies that do have existing enforcement authority. So that's why you'll see them in the partnership. Sections 11 and 12 contain the data sharing provisions to better enable agencies to coordinate enforcement. That's something that's really important for the Department of Revenue. Sections 13 through 15, there's some definitions. It provides more enforcement tools for these violations. Updates the definitions to better align with those other changes. Sections 16 through 14 really are about enforcement, enhancing and clarifying investigative and penalty authority, including the penalties for failure to remedy notices of violations, assessment of damages, penalties for obstruction of investigations, expands grounds for summary suspensions of permits, certificates, licenses, and registrations. Allows for orders to be issued against individuals, changes some of the stop work orders. Really, this is about making the investigation and enforcement authority just like clearer and stronger. And then section 25 is the construction contractor registration. So that's from previous legislation requiring those folks to register, and clarifies the ability of the registration requirement by better defining the actual covered work and geographic scope. Clarifies and modifies information and documentation needed for registration. It clarifies prohibited activities, explicitly prohibits requiring misclassified workers to register as contractors. It replaces investigative and enforcement authority in section with the authority set out in the other statutes, expands permissible use and sharing of application data. Again, just intended to provide more clarity about the construction contractor registration requirements and what's prohibited to really facilitate our public understanding and our enforcement.
Thank you, Senator Oumou Verbeten. Senator Friends.
Thanks, Mr. Chair, and thanks, Senator. I am a yes on your bill. I want to thank you for making the basic point here, which is that we are rewarding good actors in the marketplace, protecting competition, and hopefully lifting up Minnesota as a place you can trust people to do business. To that point, a couple finance-oriented comments. As we forecast the penalties, I share Senator Dames's question, which is we're trying to deter the bad actors, right? And so if we are successful, we can assume that the incidence of bad acting is going to go down. Hopefully the revenue from penalties will go down because we'll have less bad actors. And then, we're not doing our job here without mentioning those good actors want to make sure they remain unaffected negatively, that is, by the bill. We don't want to have contractors in construction or outside who are worried about this or unduly swept into a misclassification point when they shouldn't be. Having said that, this is a good bill. This is exactly the point we should be making. And like wage theft, this is a step in a positive direction for Minnesota to say, if you play by the rules in the state, we will make you a happy, prosperous place to work for the men and women who do it and to own it too. Thank you, Mr. Chair. Thanks, Senator.
Thank you, Senator Friends. Further discussion or amendment? Senator Pratt.
Well, thank you, Mr. Chair. I'm just kind of curious about the bill, how the bill interacts with the fiscal note, in particular around the penalties and the penalties assessment, and how we've come up with the additional penalties. Are we expecting to identify more bad actors? Are we increasing the penalties that will be assessed. How are we getting to $1.3 million per biennium on an ongoing basis?
Mr. Olofson?
Mr. Chair, Senator Pratt, if you'll look on page 8 of the fiscal note, that really walks through the different penalties and additional assumed new penalty revenue to the Department of Labor and Industry. So currently there are approximately, let me see here, 6 misclassification investigations each year, 4 in construction and 2 in non-construction. This assumes there will be, due to the stipulations in the bill, there will be 4 more investigations in total. So for a total of 10 investigations, 6 regarding construction, 4 in the non-construction industry. So with the changes in the bill and additional penalty revenue, they're assuming 220, so this is on page 8 of the fiscal note, just dealing with misclassification. So about in the middle of it, to get to that, just to get to that 612,000 number, I'll walk through how we got there. So there's $225,000 beginning fiscal year 26 of $5,000 for 40 misclassified, 5,000 times 40 misclassified individuals, and 2,500 times 10 misclassified individuals to get to 225 grand per year. For failing to classify, that's $125,000 per fiscal year based on 50 violations. For failing to report or disclose to any person or to any local, state, or federal government agency an employee when required to do so, they're assuming $125,000 in penalty revenue. That's assuming $2,500 per 50 violations. On line 4, they're assuming $75,000 for requiring or requesting an employee to enter an agreement or to complete any document that misclassifies, misrepresents, or treats an employee as an independent contractor. So they're assuming 10 violations of that amount at approximately $7,500 per violation. For obstructing an investigation, it's $1,000 per day per person, and they're assuming 7 days there. And then line 6, $30,000 from 3 violations for conditioning payment on an employee registering as a contractor, agreeing to be classified as an independent contractor, or forming a business at 3 violations. And on lines for the 7th, requiring an employee to register, that's a $25,000 of assumed penalty revenue of $5,000 per violation with 5 violations. So that just for the $612,000 for the misclassification. For the registration-related penalties in Section 25 of the bill, they're assuming $90,000. So this rolls on to page 9 of the fiscal note. So for providing or performing construction or improvement of services without being registered is up to $10,000 of penalty per violation per day, and they're assuming 14 days of approximately $5,000 penalty. And then for also in the registration, requiring an individual who's an employee to register, they're assuming 2 violations of that of $5,000 per penalty. And then for engaging an unregistered person to provide or perform building construction or improvement services, if required to be registered, they're assuming 2 violations also of $5,000 per. And then, as I mentioned before, they're assuming penalty revenue from stop work orders. They're assuming 1 stop work order per year beginning in fiscal year 26, and they're assuming each of those stop work orders will last 2 days to get to the $10,000 per fiscal year. With that, I'd be happy to ask.
Senator Pratt.
Thank you. Thank you, Mr. Chair. Well, I'm a little concerned that we're increasing these penalties so high for 10 investigations. 10 investigations in a year. We've got 2.2 million people in the state of Minnesota working. I don't know how many registered businesses we have. We're talking about 10 cases? How many employees are affected by these 10 cases? Do we know that?
Senator Oumou Verbeten.
Mr. Chair, Senator Pratt, I don't know the exact number of employees. I think that would vary depending on the investigation. One thing that I do just want to point folks to in the fiscal note, we've also brought this up in multiple committee stops, is just that there are factors that the agency has to look at for these penalties, including like the gravity of the violations, the number of the violations, whether there's a history of past violations. So I think when we get to the point where those penalties are issued, these are pretty, serious violations, and those are the folks where we're talking about it being a business practice. We really do want to make sure we're deterring them from continuing this model of misclassifying and exploiting workers. I can also say from my time on the Labor Committee and the task force, having heard hours of testimony from workers, it's really hard for them to come forward, it's not a great process. People don't want this to happen, and it takes a toll on those workers to have to come and share their stories, and they do it because they know, they don't want to see this happen to more workers, and they're seeing it increasingly become this business practice. So, I don't know that exact number for those specific violations, but I think we can point to things in the OLA report, in the testimony we've heard from workers, that this is a serious issue across our state, and we do want to have some intentional strategic enforcement to deter the entire industry from pursuing this practice.
Senator Pratt.
Thank you, Mr. Chair. Well, Senator Oumou Verbeten, I sit on the Labor Jobs Committee. I chaired the Jobs and Labor Committee for a while, and no one is suggesting that we tolerate misclassification in any way, which is why we've, I think, got some very robust laws. And we've looked at these issues over many, many years. I'm concerned, as Senator Dreiheim alluded to, that the task force that looked at this was a highly partisan task force. And I think we've got a solution here that's a highly partisan solution. But, I got a note from someone that according to the Secretary of State, we've got roughly 1 million businesses in the state. And we're talking about 10 investigations. We're talking about basically 1/1000% of the businesses that are accused and investigated for this problem, and yet we're suggesting that we're going to increase the penalties roughly $71,000 for each one of these investigations. And Senator Oumou Verbeten, when I worked on the wage theft bill, and a good bipartisan bill, I think it still needs some work, and we've had problems tweaking it along the way, but it was a good bipartisan bill. We came to an agreement that if you earn a wage, you should be paid that wage. It's something that Republicans and Democrats can get behind. And we had a standard in that bill that in order to be criminally liable, you had to be intentionally trying to defraud. I think in this section of law, we've typically tried to make it so that it's a willful, for the penalty, it's typically a willful violation. If it's just an honest mistake, it's the first time it's happened, we've waived that fee. It seems to me that we're lifting that willful standard in this bill. Can you comment on that?
Senator Oumou Verbeten.
Thank you, Mr. Chair, Senator Pratt. I would say that in general, for those like criminal violations, I do think those standards should be higher. What the department is doing is, again, going through a variety of processes, including, informing and educating to ultimately, in the most serious cases, right, issuing those penalties. And I think when we talk about those numbers and what those cases are, those are the most egregious, and that is where we want the department to focus their energy. I do think also the way that we're seeing this classification sort of happen in practice, there is a need to address the sort of multiple layers, that successor liability. We can see that in the numbers when there are these, these projects, for example, in construction where like that is coming from somewhere. That's coming from exploiting workers. There are people who are using this as an intentional business practice, and they know that those stolen wages, stolen taxes are why those prices are coming down. So I think it's really important to have that sort of level of accountability throughout the process. The general streamlining here in the bill is what's going to help make the department more effective in these investigations. And then again, the partnership itself is really crucial because of the different ways that misclassification impacts workers and our community as a whole. And so having that better coordination is key.
Senator Pratt.
Thank you, Mr. Chair and Senator Oumou Verbeten. Well, a lot of what you highlighted is what the department will do, is what the department already does. It already investigates. It already educates. Is it possible that a misclassification could be an honest mistake? Could it be that a misclassification is simply what do I want to say, a difference of opinion? Because we have criteria in which to measure that against. And is it your intention that those employers should be fined?
Mr. Chair. Senator Pratt, I think, again, looking at the fiscal note, we can even see that there are those times where they're going to use the inform and educate process. If you look at page 6, just looking at the construction-related inquiries, there were 2 that resulted in wage claims. There was 1 that resulted in the inform and educate process, probably an example where that person just needed a little bit more information. There were 4 that were pursued as investigations. There are different paths that the department is going to take depending on how egregious that is, and the penalty is going to be different depending on how egregious that violation is as well.
Senator Pratt.
Thank you, Mr. Chair. Well, Senator Oumou Verbeten, is it your contention then that the department's not doing any education today and outreach?
Mr. Chair, Senator Pratt, the department is doing that inform and education process, as again has been outlined in their fiscal note. I think that's something that they take a lot of pride in, and there are plans to do that. There's a whole outreach section here specifically for this bill to make sure that they're contacting, those employees and employers and those sort of organizations that can help reach folks in this industry to make sure they know about upcoming changes and know about, existing law and how that impacts them. I think that's something the agency has prioritizes and will continue to prioritize, hopefully with the passage of this bill.
Senator Pratt.
Thank you, Mr. Chair. Well, thank you, Senator Oumou Verbeten. I guess I was misunderstanding your comments because it was coming across as pointing to the fiscal note that here's what we're going to be doing with these additional fees, functions that the department's already doing. And so I just wanted to clarify that your bill wasn't creating a new function. It was just simply either supplementing or supplanting the funding that's already going there. And I made an error in my math. I guess we're looking at, $32,000 per investigation. I was looking at the biennial number of 71. And Senator Oumou Verbeten, you have in your bill for construction rights to civil action that can be taken, but it doesn't appear that any other employee group has that right of civil action. Can you talk about that, please?
Thank you, Mr. Chair, Senator Pratt. I do think it's important that there is the private right of action for employees. So, there's the role that, again, all of our agencies have in enforcing this, but also if workers want to take it upon themselves to go after an employer and hold them accountable for misclassifying them, then they would have the ability to do so for general misclassification.
Senator Champion, do you have a comment you said on something that Senator Pratt?
Thank you, Mr. Chair. I just had a clarifying question.
Oh,
because
okay.
A
Then we'll,
constituent
no,
asked me a
I'm sorry.
question, so that we can stay.
I'll let Senator Champion clarify. That'd be helpful.
It's actually about a slightly another area, but I'll ask the question. Good morning, first of all. Thank you. I've been listening online, and thank you. I think you've been doing a wonderful job on the bill. But here's my specific question, because I got a call, because I used to represent the National Association of Minority Contractors, and so some of them had some concern, and not concern where they were like, no, but they wanted something clarified. Now, I recognize that there's a couple components to the bill, but will this bill change or impact the industry-specific test for construction industry folks in Minnesota, such as a window installer? So let's say, for an example, I asked, and I don't mean any disrespect to this company, but let's say I asked Anderson Windows, or they were asked to come in and put in windows only. They don't do anything else. It's really specific. Would they be under the construction test that you have, and would this bill impact them?
Senator Oumou Verbeten.
Thank you, Mr. Chair. I just want to clarify one other thing, which is that previously, the private right of action was just for construction workers. And so, again, as I mentioned, this is now for general misclassification, so all workers. That was also mentioned in the OLA report. Section 8, to your question, Senator Champion, is the independent contractor test, where there are changes, streamlining what those changes are. I would have a difficult time sort of answering your specific question. I know that our commissioner, Commissioner Blissenbach, is here and could potentially speak to that. What I would point out as some of examples of those clarifying changes are previously for compliance, there was holding a federal employer identification number, or filing those self-employment tax returns. We're now making sure that it's both the federal employer identification number and the Minnesota tax identification number receiving those 1099 forms. So you can see how that's just clarifying that general factor there around your status and the taxes you're paying. There are other sort of clarifying changes here in the test and those factors, but to your specific question about that specific type of business, I think the commissioner can speak to that.
Commissioner, welcome to the committee.
Thank you, Chair Marty and Senator Champion. So the independent contractor test that exists in Chapter 181 is for building and construction services when there is a agreement to provide with an independent contractor in the course, if their role is in the course of building and construction services. So in the situation you describe, if a window installer is contracting with a general or someone higher up on a contracting chain, they would need to meet the independent contractor test. The current test that's in place, they would have to meet that now, and then this is a slightly revised independent contractor test for building and construction services moving forward, if the bill passes.
And just as a clarifying, so But the scenario that you gave, maybe is because I started it, is if a contractor, a general contractor needs to replace windows as a part of that, then I heard that perhaps that test would be there. But what if it's a homeowner who calls someone and says, hey, I want you just to replace my windows? Then how would 181 or this modification impact that sort of work, if any way?
Commissioner.
Chair Marty, Senator Champion. In that case, then the test would not apply. So the requirement is when an individual is providing or performing services in the course of the person who's contracting with them in the course of their trade, business, profession, or occupation. So that would not apply to a homeowner. It would apply if they are contracting with someone in the building and construction services industry.
Further discussion, I see Senator Pratt, I'm not sure if you were finished, but Senator Draheim and Senator Westrom, I believe, as well, and Senator Murphy.
Thank you, Mr. Chair. And while this is a little off of the line of questioning I was going down, I appreciate Senator Champion bringing this up. So the federal government currently has about a 6-point test. Minnesota has a 9-point test for determining who is an independent contractor, who is an employee. I believe the bill increases this to 14. And Mr. Chair, if I might, even on DLI's website, it lists the 9-factor test. An individual is considered an independent contractor only if he and she maintains a separate business, holds or has applied for a federal ID, tax ID, is operating under a contract to perform specific work, is incurring the main expenses related to the services that the individual is performing, is responsible for satisfactory completion, receives compensation from a person or services performed under the contract on a commission or per job competitive bid basis and not on any other basis, may realize a profit or suffer a loss under the contract to perform the services, has continuing or recurring business liabilities and obligations, and the success or failure of the individual's business depends on the relationship of business receipts to expenditures. So that seems pretty clear. And I think to Senator Champion's question, I'm curious as to how this is being impacted to say his businesses that have reached out to him when they meet this, and what will the additional tests be? This seems like a pretty comprehensive test. It's more stringent than the federal government has. What are the other pieces that are being added to this test to make that determination?
Senator Verbeten.
Thank you, Mr. Chair, Senator Pratt. Again, I would say these are really clarifying changes. In Section 8, you can see them all listed. The easiest way to place that in the bill, it starts on page 9, line 19, and then goes to page 11, line 22. But I think the successor liability is really important. Again, thinking about how we sort of see misclassification work specifically in the construction industry. This test is going to expand on those prohibited activities, making sure that a person that is treated as an individual, as an independent contractor, does retain those records, and that the determination is based on and provide those records to the department on demand. So I think those are clarifying changes. I already talked about some of the clarifying changes on the tax status and that information that you would need to hold. But if you have a specific question about a previous factor compared to the new factor in the test, again, would point to that section, but I can answer any specific questions you have about individual factors.
Senator Pratt.
Thank you, Mr. Chair. I'm just curious as to why we are, the current standard seems fairly clear to me. I'm trying to figure out what the motivation is, and maybe the commissioner can talk about what the motivation is for making the changes, because I'm just, again, we are already, we basically talk about an independent contractor, is on their own. They're not specifically tied to an employer. They have the ability to move without penalty. They bring their own tools to the job, whether it's a sole proprietor or an LLC or any other type of business structure. They're responsible for the profit and loss. I'm just curious as to why we're adding these additional 5 tests, and what have you found in your investigations that would lead you to these 5 additional tests?
Commissioner.
Chair Marty, Senator Pratt. So a number of the changes that are reflected in this bill are based on some of the experience of the department in looking into misclassification of the construction industry and some challenges that we've encountered. So one example I can give is the current test requires a contract, but doesn't require that it be in writing. So we are often doing investigations. We are quite confident that there is misclassification happening. We're looking to see if a contract exists that would describe the scope of the services that the subcontractor is supposed to be providing, and everybody is saying, well, it was a verbal contract, and we can't go in and show what was the scope of services, what was the basis of the payment, things like that. So that's one of the changes that you'll see reflected in the new version of the test represented in this bill. Really, the test is focusing on 2 things, and this was stated by Senator Oumou Verbeten earlier: the legitimacy of the business entity that is doing the subcontracting, and the legitimacy of the contractual relationship between the 2 entities, and showing that exists, and therefore a true independent contractor relationship exists. So it is 14 factors. Some of those 14 factors are building out the 9 factors, and some are even taking a 9-factor and putting it into different factors to clarify that they are different factors. But it is really to that point, legitimacy of the relationship and legitimacy of the entity.
Senator Pratt.
Well, thank you, Mr. Chair, and it's interesting because when we did the small business grant program during COVID, and Senator Champion will remember this well, we had a provision in there that businesses had to be listed with the Secretary of State. We wanted to get to that very legitimacy question, and what we found is a lot of small businesses, a lot of sole proprietorships don't take that step. And we ended up having to go back with deed and revising that criteria. And so my fear here is that we're going to be making criminals out of a lot of businesses, a lot of small businesses that don't have the wherewithal to take this on. And there are, just the idea of a contract being written or verbal is not the only criteria that's being looked at in the 9-factor test. It seems like there are a lot of other pieces in the existing criteria that already get to the legitimacy of the business when you start talking about they're on a commission or a per job competitive bid basis, or whether they're whether they have a tax ID number, or whether they have their relationship and their success is based on business receipts and expenditures. I'm not seeing where the current test is failing in determining that legitimacy of the agreement. But Mr. Chair, I know there are some others with questions, and I'd like to come back to this maybe a little bit after we hear some of the other questions. I don't want to dominate the conversation.
Thank you. Senator Draheim, then Senator Westrom, then Senator Murphy.
Thank you, Chair, and thank you, Senator Pratt, for not dominating the conversation. And thank you, Commissioner. I'd like to focus a little bit on the numbers a little bit. And, I looked on this page 8 of the fiscal note and the assumptions on the penalties. And then I look at where the existing numbers are from Dolly. And, we have 3.1 million Minnesotans in the workforce. We have 1 million companies. Those are big numbers. To Senator Pratt's point, there are people that don't have an entity that work off their Social Security number and file taxes on their Social Security number, which wouldn't probably be classified as an entity, but that's in the weeds. What I want to talk about is the fact that Dolly only had 99 inquiries of misclassification in 23, per the fiscal note. 99. It's less than 100. And only 23 of them were in construction. We have a lot of contractors in this state. And I get a kick out of the verbal contract versus a written contract. I don't know how many job sites I've been on trying to sell a property or a development that I'm involved in, where you'll have the general contractor meeting a subcontractor, and they'll be talking about the job, and they've done 30 other jobs just like it. And they'll say, yeah, I can do that driveway for $10,000 or $5,000 or whatever it is. And he'll say, okay, go ahead and get it done. Now, under this new bill, that would be illegal. And will also drive up the cost of building homes. And we do not need higher costs for rent or for people purchasing homes. For 23 inquiries, 23, that's it, 23. And when you drill down, only 15 of those 99 were misclassification. And then you drill down even more, of those 23 contractors, which you keep on talking about in every committee you've been in, that's all you've mentioned for the most part, is the construction industry. We had 2 with wage claims, 2. 1 resulted in inform and educate, whatever process that is. So we're talking minute numbers, very minute numbers. And now we're going to make already complicated classification. And so everybody understands, deed has one definition, Dolly has another definition, Department of Revenue has a definition, and the federal government has a definition through the IRS. And, you know, I think of a lot of contractors and friends of mine that are new citizens, and a lot of them go into the trades. And a lot of them have a great work ethic. And they're very skilled at their trade, but they're not very skilled in paperwork. And understanding how complicated you're making this very simple independent contractor. But look at the numbers, members. We're doing all this for 99 inquiries. 99. Those are just the complaints. You know, you see in this handout here, the Minnesota Attorney General handout, you can look at who was on this task force. And I mentioned this before. It doesn't seem very inclusive, especially when all we hear in all the committee stops is about construction, construction, construction. I'm disappointed that this working group, if you will, wasn't bipartisan. I have a hard time taking any group that isn't bipartisan. Senator Frentz and myself were involved in a task force, very bipartisan. Had every walk of life in it on the communication and the discussion. You know, I was outnumbered, probably 30-1 as a Republican, but at least there was a Republican in the room. Here, we don't have it. We don't have the numbers to justify the changes and making it more complicated, let alone increasing all of the penalties. So you go from 99 inquiries of wrongdoing, and I think we're down to 10, right? So 10 we're doing something wrong or found to be doing something wrong. And obviously there's probably more in that. But, and then you look at all the penalties that in this fiscal note talk about. There's a couple hundred different violations here. I question the fiscal note. I question the intent of the bill on why we are changing it when there isn't a need. You know, I think we have existing laws on the books already. If they're bad actors, let's go after them. I don't think anybody here wants anybody to work for free. And, you know, my brother in college did get taken advantage. He worked all summer for a painter and never got paid what he was owed. So it does hit close to home for me. So we don't want that. But there are remedies out there for people that are taken advantage of. But I just don't think this is the answer. And I just urge all the members to look at the fiscal note, look at the numbers, and then really think, are all these changes necessary? Thank you.
Thank you. Senator Westrom.
Mr. Chair, Senator Oumou Verbeten, is it just construction industry that you're going after here, or what other independent contractors would be covered? I know there's a lot of ride services and taxis, Uber, Lyft. Many of those models have people with an independent contracting ability or status. Who else is going to be covered under this?
Thank you, Mr. Chair. Thank you, Senator Westrom. It sort of depends on what you mean by this in the bill, but you know, for example, the private right of action that used to be just for construction workers is now for general misclassification, so all workers are able to do that. If we're talking about other industries where we've seen a lot of misclassification, I mean, it can be anywhere from administration support to professional services to healthcare, waste management. We know it exists in a lot of industries, and in fact, the OLA report said that there's an estimate that 1 in 5 workers were misclassified at some point.
So, Mr. Chair, Senator, the taxis or rideshare or other travel services would be covered under this as well. Is that correct?
Mr. Chair, Senator Westrom, there are tests that exist. There's a general misclassification test, and then there's a separate test for construction workers. So I think some of the discussion we were just having around some of those clarifying changes, the only test changes in the bill are for the construction independent contractor test.
But, Mr. Chair, Senator Oumou Verbeten, the investigations would go to any of the classifications or misclassifications as it's being characterized? Is that correct?
Mr. Chair.
So, taxi services or Lyft or Uber or other services, as you kind of listed, multiple people, healthcare workers, et cetera, et cetera?
Mr. Chair. Thank you, Senator Westrom. That would fall under the general misclassification test. So if folks are violating that test, then yes, Department of Labor and Industry would have, authority over certain violations, as would Revenue or Attorney General's office, or potentially Commerce for commerce fraud. But that's there are different tests depending on, there's a general misclassification test, and then there's a construction worker test.
And Mr. Chair, Senator Oumou Verbeten, those other groups we're talking about, some with a different test, but are going to all be subject to the new investigative authorities or fines and penalties that we're covering under this bill, correct?
Mr. Chair, thank you, Senator Westrom. Again, really depends on which sections you're referring to, but yes, there are changes to penalties for general misclassification, which would impact, a number of industries. And then as far as the actual test itself, there are only changes to the construction worker independent contractor test.
So Mr. Chair, Senator Oumou Verbeten, I noticed your answer to Senator Champion was a long answer to a short question. If I'm wrong, I would like you to correct it, but I think Senator Champion, the short answer to your question and your constituent concern is, the answer is yes. This will affect the window installer as an independent contractor. But Senator Oumou Verbeten, it wasn't real clear with your answer, but if I'm incorrect and it's not going to affect Senator Champion's constituent, can you clarify why it's not going to affect them per the commissioner's comments, which it all in the bill looks like it will?
Senator Oumou Verbeten.
Thank you, Mr. Chair. I mean, there are tests. There are just existing tests right now. There are existing penalties right now. So, Senator Champion had a specific question that I asked the commissioner to speak to, because I think she would be best equipped to answer that specific scenario about how that would apply and if that was in the construction worker test. But there are existing tests and there are existing penalties. You can't misclassify workers. That's the case. What this bill is really trying to do is streamline some things in the independent contractor test, make sure that we have adequate penalties, and then most importantly, make sure the agencies that enforce are coordinating with each other so that again, we can really address where this is becoming a business model and hold those folks accountable. But I mean, if you're misclassifying workers, yes, you can be investigated.
But Mr. Chair and Senator Oumou Verbeten, your bill is changing it. So those window installers that Senator Champion talks about or exist in my district will now, they might be complying today, but under this new test, it will change and they will have to now meet more tests, correct?
Senator Oumou Verbeten.
If your bill passes.
Thank you, Mr. Chair, Senator Westrom. If this is a situation where we would be subjecting them to the independent contractor test, yes, there are changes. There are no changes to the general misclassification independent contractor test.
So Mr. Chair, Senator Oumou Verbeten, your response to Senator Champion was noteworthy. You referred to the changes in subsection 8 were complicated and you're not real clear on them. Can you walk through them for us? Because I think it's pretty important that the whole committee, including the author of the bill, would understand the changes to what we're going to impose on our constituents that are trying to run a small business or make a living. And so can you walk through them for us so we make sure that the committee understands them, but also you, because your answer indicated to us that you didn't understand them fully, and that's why you weren't you said they were complicated and it wasn't easy to explain. So
Senator Westrom,
why don't you walk through them?
Mr. Chairman.
Senator Pappas.
Mr. Chairman, I think we've wandered far off the jurisdiction of the Finance Committee. Perhaps these questions are better to be asked on the floor, my opinion.
And Senator Pappas, I was about to make the point that I think Senator Verbeten already went through this provision. And again, this is the Finance Committee, and I'm trying to let people talk about the concerns they have, but I don't know unless Senator Verbeten feels there's something to add to it, that she's already talked about the changes. Senator Pratt.
Thank you, Mr. Chair. Well, I think what Senator Westrom is getting at are the number of complaints and investigations that will be had, and that, according to the fiscal note, is directly correlated to the additional fines that are expected to be collected. So I think this does apply to the fiscal note and is an appropriate line of questioning.
Senator Oumou Verbeten, do you want to go through that anymore? Your decision.
Thank you, Mr. Chair. I just would like to clarify that to Senator Champion's question, I talked about some examples of clarifying changes in Section 8 of the bill and asked the Commissioner to speak directly to them. I think it would be a mischaracterization to use what I described as clarifying changes as complicated. They're clarifying changes. I walked through Section 8 of the bill when I did the initial walk through section by section. We've had some conversation about what those changes are to the independent contractor test. If you'd like me to walk through the changes in Section 8 of the bill again, I can, but I think it would be helpful to get some direction from you, Mr. Chair, as to how that's related to specifically the fiscal note and how that connects back to potential penalties from DLI.
Mr. Chair.
Senator Westrom.
Mr. Chair, to try to narrow this, Senator Oumou Verbeten, I think it would be helpful if you can specifically walk through the changes and how you see them being what is specifically being changed and why that needs to be added into this test. Just focus on those changes.
Senator Verbeten, we have several others who wish to speak to the bill yet as well. If you feel there's any way you can help clarify what he has, his concern, I'm not sure if there is a way that, but go ahead if you want to.
I'll just, Mr. Chair, thank you. I will just point out a few things that I think are important in Section 8. I would say, again, the general balance we're trying to strike here is that is an independent contractor a separate and legitimate business entity, and is the contractual relationship a legitimate business-to-business transaction? There are now the ability for individual and successor liability, which is really important in this industry. There's the requirement that a person being treated as an individual, as an independent contractor, retains records and provides those to the department. I think an example of that is the written contract that the Commissioner spoke to. I would also point to those clarifying changes on the sort of like tax information. A lot of it is similar, but just adds in things that are specific to Minnesota and making sure information that was provided to IRS is also provided to the Department of Revenue. I think those are some of the clarifying changes that are in Section 8.
Senator.
Mr. Chair.
Senator Westrom.
So, Mr. Chair, thank you, Senator Oumou Verbeten. And Senator Oumou Verbeten, it was your answer that gave me pause that you as the author pushing this, gone through 4 committees before this, refused to go back to the Labor Committee because of the appropriations that was added here and today, and then not knowing the section yourself and saying it was complicated or something to that, as you answered the question for Senator Champion, just underscores that this bill is not ready for prime time, but what it's going to do is leave a lot of doubt and a lot of things up in the air and uncertainty for our small business owners across the state, because most of these are small business owners. There's a few big ones, certainly. But by and large, in my district, it's small business owners, like one that met with me in my office last week in the building trades. And it is a difficult environment out there to even find anybody to show up for work, much less get the job done and comply with all the paperwork and the headache. And now we're talking, as Senator Draheim brought up, verbal contracts now aren't going to be allowed, so that somebody's out of compliance because they didn't have a computer printer in their pickup. It's a lot like farmers, Senator Oumou Verbeten, and I realize you probably don't have a lot in your district, but let me just share that perspective with you. A farmer's office, it's often joked about in my area that the end gate of their pickup is their office. That's very similar to construction working. That's where they're at. They're out landscaping, they're out fixing driveways, they're out fixing houses. They don't have computers, they don't have lush offices, air conditioning, desks to sit at, file drawers that are just organized that they might be in the IDS tower downtown Minneapolis. So these changes really get to be hard hitting on the small business. The big businesses, they can hire HR staff and people that can comply with all kinds of more regulations. It makes me think of the farm, the small farm that we visited on Ag Committee, Senator Putnam and our Ag Committee last winter, late fall, out in central Minnesota, Melrose. And the family farm, Senator Putnam was there, had lined up. And we just asked the question in the end as we were in their dairy barn, literally with the cattle. You could hear some cows going to the bathroom. You could hear them mooing. You were right in the middle of it. And the question somebody asked is, what could we do as government to help you? And this small family farm that milked about 100 cows said, just don't regulate us more. Just help us so you don't keep adding more paperwork. And what they were referring to as some of the employer mandates that came down on them with the legislature and what they passed last year. It's just more burden for them to comply with the few farmhands that they have helping them. And all of a sudden, they're the HR department, and they're also out in the barn cleaning the manure, milking the cows, and doing everything from sun up to sundown. And that's who we're talking about here as the small business owners, that you're saying, now you've got one more, or two more, or three more, or six more tests that you have to meet. Otherwise, we're going to call you out of compliance, and you and your arrangement with an employer or a contractor that gives you work so you can pay your feed your family is now going to be illegal, or you're going to be fined because you didn't do it and met all these tests that's even more burdensome than the federal government. And so that's what gives me concern. Certainly down here you've got a lot of services that use taxis, Uber, Lyft, many different models that try to offer services. And the reason many of them do it is it gives them freedom. It gives them an opportunity of success in building their own business and deciding if they want to work Friday or not, or Saturday or not, or take a week off, or if they want to work 7 days a week. That gives them freedom. And yet we're going to make it that much tougher and now make them carry a printer along in their taxi cab or their pickup truck or whatever rig they're using to run their office and business out of, especially the small ones. You don't have to worry about the bigger businesses because they've got the cushy offices and the HR staff. And just to conclude this, it reminds me of 20 years ago when the Democrats were going after the farmers. The small farmers is who they really went after because they added all these regulations for manure management and compliance of when you spread manure from your dairy barn. I grew up pitching, I can't use that word, pitching manure in our dairy barn. You just go spread it on the field because you needed to get rid of it and you can't pile it up in the barn. But no, we got to have regulations and now start running manure management plans and writing all these things down, which just requires more work and takes you away from the real job at hand, which was feeding the cows, milking the cows, keeping the cows clean, keeping the barns clean, making sure they weren't sick, and checking your livestock. And so what happens is the small farmer goes out because they can't comply with this, and the businesses just get bigger, and people throw their hands up and say, enough, I'm not going to even be a small business owner anymore because they've made it too tough. Just like the farmer last winter when we were visiting with Senator Putnam's. Just a great family in my district. But don't regulate us so we have more and more to comply with. And that's what this feels like, Mr. Chair, but I'll leave it at that until let others talk.
Thank you. I have two more on the list, Senator Murphy and then Senator Champion, and I'd like to have us try and wrap up now. As I said, we're going to be laying the bill over until we get the number to fill in on the fiscal note. Senator Murphy.
Thank you, Mr. Chair. And I'll be brief because it is the Finance Committee. I was reminded. Thank you for bringing the bill, Senator Oumou Verbeten. The longer I listen to the discussion that we're having here, the more I understand how important it is. I'll say that I'm married to somebody named Joe Faust, and he is a small business owner, and he has a computer, and it's in our kitchen. He also uses his phone to transact that business. So just want to say that computers are perhaps ubiquitous, and we use them for contracting. You mentioned the work that you have done, the task force, et cetera, but I also know that there was a report from the legislative auditor, the OLA, related to this work, and so as we've been having this discussion, I looked that up, and they start by saying we need more coordination among the agencies, which is one of the primary reasons you brought this bill. And they talk about the importance and the value of this because we are both protecting the rights of workers, like Senator Draheim's brother and that story, and we're protecting a level playing field, a competitive level playing field among businesses and employers. And both of those things are important. There are 7 recommendations, many of which, as I have read through the summary, are embedded in your bill. So I want to thank you for I can only imagine the volume of work that has gone into this. A decade ago, I had a colleague in the House named Lori Halverson who wanted to make sure that we were taking up the issue of protecting people and the use of vaping sticks and tobacco. And when we had the opportunity to do it a decade ago, we didn't because vaping was pretty new then, and people didn't really want to tackle a new something or other. We were wrong then. We should have, because now it is ubiquitous, so much so that we are passing legislation to say it shouldn't look like a school supply. I think that what you are addressing here is another one of those issues. And as we have a better understanding of what's happening, we're going to protect workers and that level playing field for businesses. That's important in Minnesota, and I want to thank you for that.
Thank you. Senator Champion.
Thank you, Mr. Chair. And let me say, my name has been brought up a couple times, so I thought it would be important for me to say that I thought you answered my question well, and I thought that it was timely, appropriate, and clear. So this is a bill that we should, continue to support and move forward in order to make sure that we have protections on both sides of the equation. So thank you so much for doing such a super job.
And Senator Oumou Verbeten, as we indicated, we will be laying the bill over until we get the final part of the fiscal note, and thank you for your hard work on this and understanding and expertise on it. With that, this bill will be laid over until we get the rest of the fiscal note, and we'll schedule it then. And with that, we have tomorrow, we are meeting at 8:30 on the legacy finance bill. And with that, this meeting is adjourned.